Hello, my name is Adam Blaylock. I'm an attorney at Miller Johnson, and we are here today for Kalamazoo Valley Community College's Title IX training. Today, we're going to go through a number of items, but first and foremost, we're going to go through the history and background of Title IX. One of the items that's really important to know is that we previously provided training on new regulations back in 2024. But since then, the law has changed and it's reverted to an older version of the regulations. And so you should anticipate that there will be lots of materials that we discuss today that sound similar but not identical to what we talked about a year ago. So turning to the history and background of Title IX. The law itself was passed in 1972 and provides that no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. Now, Kalamazoo Valley Community College, like the vast majority of post-secondary institutions, receives federal funding and therefore needs to comply with the requirements of Title IX, which means that it cannot discriminate, exclude, or deny benefits on the basis of sex to any individual. Since then, though, there's been kind of fits and starts of law related to Title IX. So Title IX was initially adopted in 1972, and initially much of the focus was based on equity in athletics. There was a revision to the regulations in 1997. And then the key point in which the Office for Civil Rights and the U.S. Department of Ed started focusing in on the use of Title IX in order to prevent or prohibit sexual harassment and sex discrimination on college campuses happened in a 2014 Dear Colleague letter that was issued. And in the aftermath of that, there was some litigation. And then ultimately, President Trump proposed new rules in November of 2018. Those rules were finalized in May of 2020. And if anyone remembers, there were some things going on in the world at that time. Those rules became effective in August of 2020. And then there was a new president that was elected soon after. President Biden issued an executive order, proposed new rules, proposed another round of new rules, and then finally issued new rules in April of 2024. Those rules became effective August 1st, 2024, which was the reason that we came out and presented this information a year ago. And then subsequently, there was a tremendous amount of litigation. Ultimately, the Biden era rules were vacated on January 9th of 2025. And the Trump rules that were effective back in 2020 became effective once again. So let's dig into those regulations and understand a little bit better what they're about. So when we reverted back to 2020, we went back to those regulations that took effect on August 14th of 2020. And again, the Biden era rules were vacated. So in response to that, KVCC reviewed its 2020 era Title IX policy and revised it to reflect the lessons learned from Office for Civil Rights Compliance Actions. There are some key components in the 2020 regulations. It includes a definition of sexual harassment. It makes the institution receiving federal funds, KVCC, responsible for equal access to education in any of its programs or activities. It ensures that there's accessible channels for reporting, offers supportive measures for all parties, a formal grievance process, live hearings, and then some informal resolution options as well. So next, we'll turn to some definitions and comparisons between the 2020 and 2024 regulations. And the purpose of that is to help point out some of the differences between what we presented last year and what's currently in effect. So first, one of those key definitions is what counts as an educational program or activity. So it's all of the operations of educational institutions. It's all its clubs and extracurriculars, and all the institutionally sponsored events. So if it's being done by KVCC, it's going to count as an educational program or activity. It also counts events where the college has substantial control. So it could include things that are not necessarily sponsored by KVCC, but where the college is operating, and that's generally going to count all of the campus properties. It does not apply to private conduct that occurs in a private location that's not part of an educational program or activity. But on occasion, Title IX may still be implicated if that private conduct begins to have an impact on a student's access to the educational program or activity. So the example that I'd usually provide in this circumstance is that there's some off-campus conduct that probably wouldn't implicate Title IX that ultimately bleeds over onto the campus because of some kind of harassment that's ongoing on the college campus. And then finally, it doesn't apply to events that occur outside of the United States. There's a jurisdictional component. It's got to happen on American soil. Next, Title IX regulations also define sexual harassment and ultimately prohibits conduct that constitutes quid pro quo harassment, hostile environment harassment, sexual assault, dating violence, domestic violence, and stalking, including cyber stalking. The regulations also strictly prohibit any retaliation for anyone participating in the process. So that includes both filing a complaint or participating as a witness. And it applies to conduct by all members of the school community, not just students. It also applies to employee conduct as well. So, returning to one of those key definitions, sexual harassment. So the return to the 2020 regulations means return to a slightly different definition of sexual harassment. So sexual harassment includes conditioning aid, benefit, or service on an individual participation in unwelcome conduct, or what we call quid pro quo harassment. It also prohibits unwelcome conduct on the basis of sex that's determined by a reasonable person that is so severe, pervasive, and objectively offensive that it effectively denies a person equal access to a program or activity. And then it also prohibits those kind of clearly defined items, which include sexual assault, dating violence, domestic violence, and stalking. So putting these things side by side so that you can see the difference. So under the 2020 regulations, quid pro quo harassment needs to be done by an employee of some kind, because it requires some kind of supervisory authority or ability to direct the conditions of someone else and their individual's participation in unwelcome sexual conduct. This is a little different from the 2024 regulations, which broadened the scope of that quid pro quo harassment. Next, we want to take a look at the definition of hostile environment. And again, the 2024 regulations, which are no longer in effect, generally broadened the application so the Title IX would apply to a broader range of conduct. But under the regulations that are currently in effect, and what we're going to be applying on a going forward basis, is that unwelcome conduct needs to be severe, pervasive, and objectively offensive. That's a reasonably high bar because it requires all of those things. Although we must note that being severe or pervasive is not a black and white kind of analysis. It's really a sliding scale. Some conduct can be so severe that it only needs to happen once in order to be actionable. And some conduct might be really relatively minor, but it's so pervasive that it still constitutes sexual harassment. And one thing that we need to know, and this is going to be an important thematic thing throughout the rest of our presentation today, just because conduct does not fall within the Title IX process does not mean that it's okay. KVCC prioritizes the safety and well-being of all of its staff and students. In conduct that rises to the level of Title IX doesn't mean that it anything other than this is the process that we're going to use to process the conduct that's potentially objectionable or alleged to have occurred. So what I'm saying is that Title IX as a whole is not about whether or not conduct is right or wrong. It's about the process that we have to follow in order to comply and make sure that we meet the requirements of the law. Finally, the definitions of the specific offenses that we've discussed a couple of times now sexual assault, dating violence, domestic violence, and stalking have not meaningfully changed. The way that it was changed was instead of a citation, the 2024 regulations reproduced the language. So ultimately, the conduct here is very similar to what we've been dealing with historically. So before we go much further, we want to pause for a brief second and talk about some hypotheticals. And the purpose of this exercise is to think a little bit about the types of conduct that might constitute sexual harassment. So in this example, we've got a faculty member who asks a student who is in a bad mood if it's that time of the month. And again, we want to keep thinking through that analysis of whether or not the conduct is severe, pervasive, and objectively offensive. This is undoubtedly an offensive comment, but the question is whether this is severe and pervasive. Now, changing the facts a little bit, if the faculty member asks that student that every class, it becomes much more pervasive and much more likely to be deemed sexual harassment. And then finally, if other students start teasing that female student, it begins to clearly impact their access to the education and is much more likely, again, to be deemed an issue that needs to go through the Title IX process. The next hypothetical is we've got a female student that teases a male student just once about a past sexual encounter in the cafeteria. Again, objectively offensive, yes. The real question is whether or not it's severe and pervasive. Now, again, if the female student teases that male student every time she sees him, it becomes much more pervasive and the conduct more likely needs to go through the Title IX process. And then finally, if the student is squeezing the male student's bottom, calling him sexy, and then the male student notes that it's bothering him and he's told her to stop, but it hasn't really impacted his daily life or education, the conduct itself is pretty objectionable, particularly because there's physical touching, unwelcome touching that's going on. But whether or not it falls within the Title IX process might depend a little bit on whether or not it's impacting his access to his education. Now, again, we're not saying that this conduct is okay if it doesn't fall within the Title IX process. We're just saying that we would deal with it with a different portion of either the Student Code of Conduct or employee handbook. Next, we've got a male student messaging a female student during class, telling her she looks hot today and asking her on a date. Now, these facts, I'm a little skeptical that they'd fall within the Title IX process. This kind of flirting and dating is fairly common in the college level, at the college level, and ultimately, we need to think about how this would be processed. But if the female student is deeply uncomfortable because she has a history of trauma and starts skipping class, it then pretty clearly begins to impact the educational environment, although it's unclear whether this conduct would be objectively offensive, right? Whether or not a reasonable person would look at this and find it objectionable, even though that particular student is deeply uncomfortable. Again, not saying that this conduct is necessarily okay, but whether or not it gets processed through the Title IX process is the question here. But we add one fact, and this changes really dramatically. If the male student also stops by the female student's residence and knocks on the door, it becomes to look very much like a matter that needs to process through Title IX. All right, next, we're going to turn to some of the process items. We want to let you know what the obligations are of the Title IX coordinator and other components that are really important for our KVCC staff to know. So briefly, going through the anatomy of a complaint. First, there's notice of alleged sex discrimination. That notice gets provided to the Title IX coordinator, who then implements supportive measures, which is something we'll talk about more towards the end of the presentation today. The Title IX allegations then may be processed through the grievance procedure. There's ultimately an adjudication, and then finally there's an opportunity for an appeal. So, as it relates to the Title IX coordinator's responsibilities, first, every college is required to designate at least one Title IX coordinator who's responsible for overseeing and coordinating the college's compliance efforts. Now, colleges may have multiple Title IX coordinators, but one has to retain ultimate oversight. At KVCC, your Title IX coordinator is Danny Alexander. And that's a name that we're going to hear a couple of more times throughout today's presentation. Now, the Title IX coordinator may delegate specific duties like investigating to others. But then the other requirement for every college is that they adopt and publish a notice of non-discrimination and grievance procedures. KVCC's policy can be found on the website at the link noted below. Now, I want to sit down and say that this is perhaps the most important part of today's presentation. This relates to the obligation of college staff to notify the Title IX coordinator. Now, as someone that works very closely with educational institutions, both at the K-12 and the higher ed level, I am always in favor of notifying the Title IX coordinator when we think we've got something that may result in a Title IX issue. So you should always feel welcome to do so. But there is a certain segment of our staff that have an obligation to do so. And that classification is employees with authority to take corrective action on behalf of the college. There are a number of listed folks here. We've got managers, board of trustee members, some volunteers, administrators, contractors, coaches, directors, deans, program directors, advisors, and others who manage student workers, as well as faculty members in their role as instructors. In short, there's a large segment of our population that has an obligation to notify the Title IX coordinator. But even if you don't have an obligation to notify the Title IX coordinator, you should provide the Title IX coordinator's contact information and let folks know how to make a complaint. So again, if you've got an issue that comes to you as a member of the college community that seems like it fits within the Title IX scope, the safest approach is always going to be to notify the Title IX coordinator. And then if you're one of the few folks that doesn't have an obligation to do that, at the very least, you should make sure that you provide the Title IX coordinator's contact information and let that student or member of the college community know how to make a complaint. All right, so once a college has actual notice under Title IX, and so that's whenever there's an issue that's raised to any of those responsible employees, the college has an obligation to take immediate corrective action if we have actual knowledge about the reported conduct. So when we do that, the college, and I should note that the college requires that all responsible employees immediately report those allegations to the Title IX coordinator. And we've designated very clearly certain folks as responsible employees. That's the Title IX coordinator, our public safety officers, our human resources administrators, the president, provost, vice presidents, department chairs, directors, deans, and other academic unit heads. But once we've got that actual notice, we have an obligation to take some remedial measures. So again, a couple places that you're able to report. One, obviously, is always the Title IX coordinator. That's Danny Alexander. And if maybe you've got an issue and you're not sure where else you can report, there's 3 other individuals that have been identified as reporting contacts. One is our student relations coordinator, that's Russ, our director of human resources, Amy, and our director of public safety, Sean. Again, their contact information is listed on the slide in front of you, and you should take advantage of that notification process if you have any issues related to Title IX. Briefly, before we get into the grievance procedure and process, I want to note that there's this opportunity in certain circumstances to engage in informal resolution. An informal resolution is designed to eliminate that harassing environment through alternative actions without going through the entire grievance process. Now, it won't necessarily involve disciplinary action against a respondent, and it requires the consent of everyone to participate. That's both parties. That's the complainant and the respondent. And sometimes it can be used when there's a request for anonymity. Ultimately, the school, KVCC, has the opportunity to offer this mediation for appropriate cases, but either party can also withdraw throughout that process as well. There is one important component. It is not permitted to be used when there's a case of sexual misconduct or harassment where the complainant is a student and the respondent is an employee. So if there's an allegation between a student and a staff member, that is not a situation where informal resolution is an option. Okay, turning briefly to Title IX grievance procedures. Our Title IX coordinator has an obligation, when notified of conduct that may reasonably constitute sex discrimination, to initiate grievance procedures or that informal resolution process. If there's not a complaint, so someone comes to the Title IX coordinator but doesn't file a complaint, the Title IX coordinator has the ability and authority to initiate the grievance process on their own. And then they also have an obligation to take appropriate, prompt, and effective steps to ensure that any of that sex discrimination does not continue to recur. When we talk about the complaints, while an initial report to one of our responsible employees does not need to be in writing, ultimately the complainant will need to reduce that complaint to a writing in order to initiate that grievance process. You should know the college has the authority to consolidate multiple complaints. Sometimes there will be multiple complaints that are filed that arise out of the same set of facts or against the same person. And the college can deal with those things all at once rather than having to initiate several investigations in parallel. We also want to know who can make a complaint. So a complainant, so that's anyone that's participating in or attempting to participate in the education program that does permit employees to make those complaints as well. And then the Title IX coordinator. There are certain circumstances where when the Title IX coordinator is evaluating a complaint that they are required to dismiss it. So on that initial intake, the Title IX coordinator must dismiss a Title IX complaint if it didn't happen in the United States, if it didn't happen within the educational program or activity of the college, or if we assume everything in the complaint is true, would not constitute sexual harassment. Now, again, and I'll reiterate this for the third or fourth time today, just because a complaint does not fall within Title IX does not mean that the conduct is okay. Just because there is a dismissal under these Title IX grievance procedures does not mean that the college does not have the authority or the ability and will not look at a matter through either the Student Code of Conduct or employee handbooks. As we always say, remember, another school or departmental policy may apply. There are also some circumstances where the Title IX coordinator has discretion, authority to determine that they want to dismiss a complaint. And that's when the complainant notifies that they want to withdraw. The respondent is no longer enrolled or employed by the recipient, so we really lack the authority to issue any kind of discipline or remedial measure to that respondent. Or there are circumstances that prevent the college from gathering evidence sufficient to reach a determination. Basic requirements in the grievance procedures require the equitable treatment of the complainant and respondent. The Title IX coordinator, investigator, and decision makers are not allowed to have any bias or conflict of interest, and the decision maker must be different from the investigator. KBCC uses a two-investigator model in order to help mitigate any risk of bias or conflict because there are two folks that are investigating these issues. There is a presumption throughout the process that the respondent is not responsible for the conduct. And then we have an obligation to provide reasonably prompt timeframes for the major stages of the process, although there are circumstances where we can extend those timeframes. The college also is going to take reasonable steps to protect the privacy of parties and witnesses, and we may require confidentiality with some limitations. Both the complainant and the respondent must continue to have the ability to obtain and present evidence, speak with witnesses, consult with folks, and then otherwise prepare and participate in those grievance procedures. And we've got to require the objective evaluation of all relevant evidence. There are certain training requirements that the college needs to engage in. Part of it is training like this. But there's also specific training that's going to be provided or has been provided to investigators, decision makers, and others responsible, facilitators of any informal resolution process, and then the Title IX coordinator and their designees. To the extent that you don't fall into one of those umbrellas, underneath one of those umbrellas, KVCC provides training more broadly in order to ensure that our staff know and is aware of its Title IX obligations. The college also has an obligation to maintain records, and those records must be maintained for 7 years. All right. I said earlier that we were going to have a discussion about supportive measures. Supportive measures, which are interim processes or interim measures that are implemented by the Title IX coordinator, are individualized measures that are offered, that are reasonably available without unreasonably burdening either the complainant or the respondent, in order to restore or preserve that party's access to the education program or activity, and provide support during the grievance procedure or during the informal resolution process. Now, some examples of what supportive measures may look like. They include counseling or extensions of deadlines or other course-related adjustments. It could include increased security or monitoring or a leave of absence or change in the class schedule. Supportive measures are generally confidential, but there are certain circumstances where the college may need to disclose the nature and the reason of the supportive measures in order to ensure that those that are implementing those measures are aware of them. So, for example, if a student requires a change in courses, it would be outside of the typical process. It would be understandable that the college would then have to disclose something to the faculty members that are involved. And then decisions related to supportive measures are something that can be challenged through the grievance. There is one exception, well, two exceptions to the general rule that both the complainant and the respondents maintain the status quo in their educational environment throughout the grievance process. First is that for students, a student may be removed on an emergency basis if the college determines that they may pose an imminent and serious threat to the health or safety of a complainant or others on the college campus, and that may justify removal. In order to do that, the respondent has to be provided notice and an opportunity to challenge the decision immediately following that removal. The second exception is that an employee that is a respondent may be placed on administrative leave pending the grievance procedure. We also want to provide a brief investigation schedule. So typically, and this is fairly typical for a Title IX investigation, so there'll be an interview for the complainant. There will be some back and forth with the respondent to potentially interview. There will be the investigators will interview potential witnesses. And then there's some procedural items that need to happen in terms of disclosure of evidence, as well as the ultimate investigation report. At the end of that process, the investigators will provide the report and the evidence to a hearing administrator, assuming we're moving into a live hearing. The investigators are not fact finders. They are there to gather the information, not to determine exactly what happened, and don't make a final determination. That is left to the decision maker or the hearing officer. So I just made mention of a live hearing process, and the Title IX regulations do require that the college provide for a live hearing. Now, there are circumstances where a live hearing may not be appropriate, but as a general rule, those participating in the grievance process will have that information provided to them as it relates to how they can request or engage in that live hearing process. There are a couple of procedural requirements in the live hearing. One is that the recording or transcript must be created. Both parties must be provided an advisor if they don't obtain one on their own for the purpose of conducting cross-examination. Neither the complainant nor the respondent is permitted to ask questions of a witness or the other party. It has to be done by an advisor. All questions in that process must be relevant, and the hearing officer has the authority to make that determination. And then at the request of either party, that live hearing can be conducted separately, separate rooms, with the use of technology to enable the parties to see and hear one another as needed. The hearing officer has the right to determine the relevancy of questions, can exclude irrelevant questions, may exclude questions that are intended for the purposes of harassment, And ultimately, the role of the hearing officer is also to protect the privacy of a party's medical, psychological, or similar treatment records, and then will ultimately provide a written determination with analysis with their findings. Next, the last stop in the Title IX grievance process is the appeal process. So there are limited circumstances after the decision is issued by the hearing officer where an appeal can be heard. One is that there was some sort of procedural irregularity that affected the outcome. That's fairly uncommon. The next, and this is the most common reason for an appeal, is that there's new evidence that was not reasonably available at the time of the determination that could affect the outcome. And then finally, the Title IX coordinator, investigator, or decision maker had a conflict of interest or bias against either the complainant or respondent that affected the outcome. An appeal must be filed within 10 calendar days of written notice of the final determination by the hearing officer. And there's a process associated with that. So the responding party can respond. The decision maker can also make a response. And then the decision maker for any appeal needs to be a new individual. Ultimately, that appeal decision maker is required to issue a decision simultaneously and generally within 14 calendar days of receiving all those appeal documents. All right, so a couple of brief questions, a brief quiz. First, who is the KVC Title IX coordinator? And the answer is Danny Alexander, Vice President for Campus Planning and Operations. Next question, where is KVCC's Title IX policy located? And the answer is on the website at the link you can see on the screen, and then copies can also be obtained from the Title IX coordinator's office. True or false? All Title IX complaints need to be in writing. The answer is true once we get to the Title IX coordinator, but don't assume that a verbal report means that there's no Title IX issue that you do not need to report. Ultimately, if a student comes to you, one of my general recommendations is to do what you need to do in order to help take care of that student. And then, what is your reporting obligation? And the answer is that if you have authority to take corrective action on behalf of the college, or you have a responsibility for administrative leadership, teaching, or advising, you must notify the Title IX coordinator. You have an obligation to do so. And if you don't fall into one of those categories, you can either notify the Title IX coordinator, which is always my recommendation, or provide that person with the Title IX coordinator's contact information and how to make a complaint. So with that, I want to say thank you for your time, and I wish you the very best in your time at KVCC.